We're back on the record in the Norcutt Council matter, case number D16537-499D.
Okay, you got a lot of noise. So,
that's me.
yeah, all right. Mute the computer. And Mom can mute herself because of the background noise because Dad's going to go first and argue. Okay, Mr. Counsel, how long is your argument going to be? I just want to get an idea. 20 minutes? 30 minutes? I don't know.
I think it's well briefed.
I'm sorry,
We couldn't say
30 minutes, maybe 30 minutes, as long as I'm not interrupted.
Okay, well, yeah, because I won't be here all afternoon, so we'll go no more than 30. It's 2:50. You'll go for 3:20. I'll give you your 5-minute warning, and then I'll have Mr. Page give his equivalent opposition if he needs all that time, and then I'll give you a 5-minute rebuttal. 5-minute rebuttal, and then because I don't have a GAL report, then I would take the matter under advisement. If there are new circumstances, we will set another hearing for Ms. Cooley to come back. So actually, let's take care of that now. We need another GAL report hearing. So I assume she's going to get with Gage.
By the second.
Gage this week. You know what would be more balanced is she interviews Gage in Vegas, and then she'll interview Gage in Seattle. Okay, like soon as he gets back home, and then we'll have it after Labor Day. So let me look on my calendar.
Your Honor, with all due respect, this motion is filed in reference to Gage is at extreme risk on even returning back to Seattle.
When is the first day of school in Seattle?
I believe the 16th.
It's like the 9th.
The night.
Yeah, it's
Yeah,
not. It's not an extreme risk to fly back home to his mom's house and then be interviewed there, and then we would have a hearing. And then we would have.
Education, Your Honor, his education and to be able to maintain his education and start in Las Vegas is the whole reason why I filed the OST.
Oh yeah, one of the kids are starting. They started today.
Yes, today, and I've already taken care of a couple other things pending on today's decision. Like I said, it's this extreme urgency that we have some sort of rectification today.
They do not have a placement for Gage in the 8th grade at Faith Lutheran. He's not even on a waiting list.
Your Honor, again, that's judicial estoppel, and that will all be proven in the exhibits presented to the court.
I'm not sure he thinks judicial estoppel means what he thinks it means.
All right. It depends when we can get the GAL report in. So if the GAL was to do her report this week, then we can get her in maybe next week. And I could issue a decision based on what I hear from the GAL and your arguments today. Just that, let me see, we're booked. Hold on. Monday the 31st, we're booked.
Remember, Gage is supposed to be in his brother's wedding Memorial weekend. I'm sorry, Labor Day weekend. He's to fly home to Washington on the 2nd and on the 4th to go back to Indiana. And we won't be
Allegedly, Your Honor, that is allegedly. I've yet to see a plane ticket or any attendance or any notification of where he's going to be staying or or traveling. So again, can we please stay on track to the matters at hand? We are not rebuttaling or arguing that today.
Well, first
Rebuttaling's not for.
like, first of all, I've been listening to you, Mr. Counsel, and let me remind you,
Thank you.
I run my courtroom as I see fit.
Thank you.
I don't have any litigant try to run me
Understood.
over and try to run the proceedings. So I understand things are a
Understood,
little
Your Honor.
things are a little tense between you and Mom, and I've been doing this 20 years, and you know I'm retiring at the end of the year, so
Yes, Your Honor.
I'm not going to let it not let it get to me. So that wedding, we talked about that wedding. That wedding is going to happen, but I need to ask Mom if the flight's going to be from Vegas to Indiana or Vegas backtrack from Seattle. You want to have them flown from Vegas to Indiana?
No, I've already purchased the ticket from Nevada to Seattle on the 2nd.
Right. So y'all going to fly over to Indiana as a family?
Correct.
Fly
And we're
together.
leaving on the red eye on the 5th.
On the 5th? So if he flies back on the 2nd, that's what I was
I'm
told.
sorry. We're leaving on the red eye on the 4th. We'll be there the 5th, the 4th, 5th, and the 6th. We fly back Sunday evening.
Okay.
First
What time is it on September 2nd?
let's see. Hang on. He arrives in Seattle at 10:10. I wrote it down. Hang on. I can tell you exactly.
In the morning?
Yeah, in the morning.
All right. So Mom has a return flight from Las Vegas to SeaTac. Arrive after 10 a.m. on 9/2/2020. Okay, Ms. Clark, I wrote in the chat box. In the court minutes. So this is what's going to happen. So he's going to fly back on the 2nd. He'll be in Mom's household environment. Miss Cooley should work it out where she can have that video call with Gage on the 3rd. Or on the 4th, because they're flying right eye on the 4th. And the wedding takes place over that weekend. And when will you be back in Seattle, or you have to get back before Seattle school starts? So when are you coming back, Labor Day or the 8th?
No, we're coming back on Sunday the 6th in the evening.
You know how late in the evening?
7:30. And I'm sorry, he leaves Vegas at 10:10. He arrives in Seattle at noon.
Page 4, yeah.
At what time?
He arrives at 12:46 in Washington, and he leaves 10:10 a.m. Las Vegas. And then
Well, you lost me there. I had written that he's flying on the 2nd, arriving after 10 a.m. on the 2nd, and you're going to be, yeah.
I'm sorry. So he leaves Las Vegas at 10, and he arrives in Washington at
46. Yeah,
Well,
I got you.
sorry. And then the other flights are we leave Indiana at 6:05 and we get home at 7:49 on the 6th. And then the flight out is that's still anyway, it's the red eye. We have 2-hour layover, and then we arrive first thing in the morning. It's around 10 o'clock on Friday morning.
That's fine. Okay, so what I have there that turn on from the wedding is a Labor Day weekend wedding.
Yeah, and then
Okay.
school,
Right, school starts on the 9th.
yes.
And Washington State. Alright, so just get those facts down. Alright, so yeah, the GA, I'll put in the chat box there. GA will do the video. call. So she'll do video calls with Gage in Dad's household environment or day camp, but I guess day camp's done today. And then she'll do video calls with Gage in Mom's household environment, so we get a balanced type of report and see how Gage responds to her in both household environments. That means that if you're back on the 6th and then Labor Day is the 7th, we should have a hearing soon after that. So, yeah. Okay.
Labor Day is on the 7th, and then there's a Tuesday on the 8th, and then school starts on Wednesday, the 9th.
Yeah, let me check my calendar. Find a hole in my calendar to have a return hearing. Maybe the 9th in the afternoon again. We'll have to make room. Ms. Clark, I'm going to override this, so we're going to do the Tuesday, September. Mr. Page, are you available on the 8th or the 9th?
I'm checking.
9th's not good. I've got a couple emergency motions there. Oh, yeah. The 9th, don't forget, is Kilgore motions. I don't know what it's about, but you're on that case, Mr. Page. So Kilgore's set for, I don't know how many motions, set for 1:30 on the 9th, since you're going to be appearing anyway.
That's to do with the remand stuff.
Yeah, so what do you think? Maybe 3 o'clock? You can fit Norcutt in here after Kilgore? Give an hour and a half for Kilgore? I don't know if it'll take that long. I'm not sure.
I don't know if it'll take that long. I mean, I could make. Well, I just won't say anything.
Yeah, I'll see what we have. It's a motion for.
On
Yeah.
this one here, I've got a hearing at 11 o'clock on the 8th, and then Kilgore.
On the 9th at 1:30.
Yeah, I should be okay on the 9th.
Anything in the rest of the afternoon after Kilgore?
No, nothing.
All right, so 1:30. Why don't we schedule Norcutt and council on, I would say 3 o'clock to be safe, even if it don't take that long. But you never know. Or, yeah, well, Mom and Dad, I can have you on standby at 2:30. Or you prefer 3 o'clock?
3 o'clock works for me. Yeah. 3 o'clock.
He's doing, well, okay. Right, so that would normally be the first day of school there, and so, yeah, it is what it is. So, and hopefully I can maybe, once I hear the GAL report, I'd have to make a decision maybe on the first day of school there. Okay. All right, 3 o'clock. We'll type that in the chat box. The return hearing for the for GAL report on 9/9 at 3 p.m. Ms. Clark, enter that into Odyssey in the 4 minutes. That's the return hearing for the GAL report.
Absolutely.
Further proceedings, okay, on the motions. Okay. I'm ready to take any other logistics. Otherwise, I'm ready to take arguments for council. 30 minutes. We'll mute Mom there. So it is 3:03. Mr. Council, you have 30 minutes.
Yes, Your Honor.
We'll let you know 5 minutes, 1 minute warning. You'll wrap it up. Mr. Page will go. He'll take his up to 30 minutes, give you a 5 minute rebuttal, and then I will just keep my notes until we come back on the 9th. Okay? All right. And
Yes,
I
Your Honor.
understand you have some exhibits, so, if you're going to do share screen function, that's fine. Mr. Page objects. I'll just rule as we go along. All right. It's 3:04 on the clock. You may proceed.
Okay, Your Honor, thank you so much for your time this afternoon in hearing this. The whole purpose of this is that, the mother is so far gone, she's in transient. And when I say in transient, she just proved it to the court as she has violated once again with not knowing, she knows that she's traveling out of state with my child. She has yet to provide any information. She has yet to notify me of when he's traveling, where he's staying, and she just proved it to the court that if she has that information at hand, she should have provided that information to me as well. Now, when I say in transient, she is so far gone. She's making a mockery of the court, Your Honor. She's making a mockery of all the court orders. You've even said it yourself, and I must say that you said it multiple times. Even when you allow the relocation, that, if certain factors are not met, you would return him immediately, Your Honor. We have gone down this path numerous of times. And the fact that she continues to make a mockery out of your orders, the whole judicial system and what this stands for, it is completely just, she's thumbing the court, and she's laughing about it behind your back, Your Honor. The court orders clearly stated, and you clearly stated, that this was a mistake allowing him to relocate, right? The fact that she is emotionally and physically, she's emotionally and psychologically abusing my child, and the fact that we need to rescue him immediately today. If you allow this to continue on, he's going to continue to fail in his education. You allowed the relocation. You allowed certain factors to be involved. I understand that. However, he has been ripped away from his passion, his gift, everything that he's known in his life. He has no structure. He is vegging out, escaping into video games. His education is failing miserably, undeniably so, as he gets older and older and older. This is a crucial time for you to recognize this, Your Honor, that right now is a pivotal point in his life. She can't even get him to school on time, Your Honor. She can't even, not only not get him to school, she has every communication that I have presented to her in Family Wizard via text. However, I can't communicate with her, has been positive, and I've tried to discuss his education. It has been miraged and responded as harassing, threatening, and basically, for the lack of a better word, no care at all from her side at all. She, and another, as in my exhibit shown, she can't even keep my son clean. He arrived in Las Vegas with clothes that do not fit him, shoes that are a size and a half too small, ringworm on his arm, his hair all the way down past his nose. She can't even do that. He's totally not only destroying his education on purpose, but she's destroying the father and son bond. And it's detrimental that we stop this today and rescue my son, Your Honor. Physical scars and are just on the surface. Emotional scars are forever. She has not only violated the orders, but she continues to do so by miraging fraudulent cases of domestic violence that have never taken place, nor have they ever been proved by the court of law. And due to her misconduct, and due to her choices, is the reason why we're in this situation. My oldest son, she also presented to the court a letter from Gavin wanting to change his last name. And that, Your Honor, you clearly stated allowing my son to relocate was a clear mistake by the court. Strictly stated straight in one of the motions that you were in. My children are not taught to be racist out of the womb, right? And out of the womb, is where you're taught certain things in life. My children have been taught by their mother to hate me. They have been taught certain things that are not true by the toxic environment and the culture of the home. A parent that runs a household runs the culture in the home. The culture in the home is defined by the parent, therefore reflected in the children's behavior. The children would not behave that way if they were not taught, Your Honor. He is now willfully emotionally abusing Gage. She ripped him away from the only thing that he was successful in Seattle and prevents him from that, Your Honor. If you look at his grades, the only thing that's positive in his grades are his athletics, Your Honor. And the fact that she is also willfully attempting to alienate me, and that's a form of child abuse. You know, not only was the move bad enough to separate the child from a strong bond with his father, it's like having two pieces of paper with glue in the middle. When you rip it apart, now you have pieces on both sides. So does she foster that relationship? Proven without a... I have submitted all the documentation. I have had witnesses testify on my behalf that the fact the mother has no justification in her behavior and actions, all that just her personal vendetta against me. No, she neglects his basic needs, Your Honor, and that's a form of parenting. She cannot even get him washed, get him bathed, get his hair cut, keep him groomed. She can't even get him to class on time. Nor does she even include me on his school records. It's like she's replaced me with an aunt and a cousin. What kind of mother does that to a father that has been positively involved in his life in all aspects, from his education to athletics, everything involved? What kind of parent does that to a child? You know, we all know that all kids that are active in sports generally do better in school, you know, with discipline and structure. And now that his mom allows him to do whatever he wants, play video games until the wee hours of the night, he has no structure. My son was ripped away from the only thing that he knew in his life and ripped away from his athletics to absolutely nothing. To nothing at all, Your Honor. To the fact that, you know, not only did she leave 5 days before she was supposed to, she cut off all contacts for over 8 months. You know, not only is the mother depriving of him of his general basic needs, she's depriving him of his education. She's depriving him of an education that will forge a pathway to the next level that will forever change his life. Children that do better in education are due to the active structure and discipline that athletics provide to a young child. And any time that I have any input on my son's interests, it gets shunned and turned away just because it's my interest. If the court has orders to put in place for the best interest of the child, Your Honor, she mocks the court by not even following the orders that you put in place. Therefore, she neglects the best needs of my child. She wants him to fail. The mother hates me so much. She wants to punish the child for having a strong bond with me and everything in life that good comes with it. You know, it's completely absurd, and she has no justification of her choices. She violated every order put forth. Their orders were clear that he was supposed to be here for spring break. Not only did I offer to fly to Washington myself and drive to Washington myself to see my son during this time, the legislature deemed that parental visitation is essential. Not only did her a la carte attorney refused to acknowledge the fact that I would take it upon myself to drive to Washington to see my son. They didn't even allow it. They withheld my son. Not only did they withhold the visitation that was ordered by the court in his best interest, they denied the whereabouts of where they were located. So therefore, I had to call the Auburn Police Department multiple times in the exhibits that I provided to the court to show that she was not at her residence at the address that she's provided. She was not reachable. She didn't notify me at all. So you have a worldwide pandemic, allegedly, that we have all of these issues in place. But it's not in the best interest of my son, or it's not in the best interest of my child for his father to know even where he's located, where he lays his head at night. It's clear beyond any visible reason of doubt, Your Honor, that the relocation was not in the best interest of my son. It was a personal vendetta, a vindictive vendetta to wipe me from existence except for a paycheck. The only thing, Your Honor, due to the Miss Norcutt's misconduct, I have not been able to pay any child support but bare minimum whatever I can afford at that point in time. That's all that they have. That's the only thing that they have negative towards me, is not being able to pay the child support, but it's based on her misconduct that has forced me for the best interest of my child to be a positive figure in his life. Now, Your Honor, I have had a strong bond with Gage since he was been born. Strong bond. To rip him from something that he has known his entire life to nothing in an environment that is depressing as it is anyway, with cloud cover, the weather is not the most, enjoyable experience at all. So his complete education has failed. He is escaping into video games. He's not dealing with life. In fact, he's not dealing with true life. He's escaping, and he's not been able to express himself or deal with things or even allow to talk to his father. If you have a child and it's in your best interest, you have a daughter who's interested in ballet. She's interested in theater. If you get her involved in plays, you get her involved in presentations, you get her involved in musicals, you cater your life around your child's development and the best interest of the child. Well, if this court order is in the best interest of my son, then it's a complete misconduct for her to willfully prevent him from participating in something that he has done his entire adolescence with the age of 5. The age of 5 to absolutely nothing. Not only was I not allowed to see him.
You're a little muffled. Does he sound a little muffled?
Yeah, he sounds like he's in auto or something.
Yes.
Little muffled.
Okay, one moment.
Yeah.
I'm sorry.
Hello?
Hello?
One moment.
Your time.
I'm sorry, did you hear anything?
I was last 50 seconds kind of muffled. I'm listening to your argument, and I don't want you to waste the last 15 minutes of your 30 minutes. I'm looking for facts, objective stuff, grades comparison, what happened with spring break. This is stuff you wrote in your motion, and
Okay, Your Honor.
I appreciate
Here's the facts right here. Okay, the going on page 2, that you stated that allowing Gage to move was a clear mistake by the court, and the court recognized that mistake, right? The mistake was the fact of allowing him to go to Seattle. And the mother defies Gage's best interest just because I make a statement or if I have input in his future, causing invisible and tangible emotional abuse that's life damaging. This is a detriment to Gage's education and his future abilities, Your Honor. He's been recognized as the #1 athlete for his age and potential D1 college athletic scholarships that completely wiped from existence just because if I say so, if I have input towards that, right? Gage entered the 6th grade in 2019. Right out of the gate, he has a tardy the first week. There's 22 calendar days in the month of October. Gage was tardy 3 times. There's multiple issues of behavior reports documented clearly in the exhibits presented by the school. Multiple tardies in November 2019. There's 14 school calendar days in the month. Gage was tardy 5 times with 2 behavior incidents in the max of 14 days. December 2019, he had 14 days in a month. He was absent 3 days. It's clear that she can't even get into school on time. Nor is it she's had 2 years of my son to make a difference, to make a positive impact. She has failed to do so, and she has failed to do so with no other intentions than to harm me, just because of her personal vendetta. Going into the 7th grade school year, Your Honor, Gage continues to have numerous behavior issues. His GPA is 1.5 at best. This is 7th grade, Your Honor. He's not even should have been allowed to go to 7th grade. He should have been held back in 6th grade because he didn't even meet the 6th grade requirements. He's not even reading at that level. So when you ask me of tangible evidence or statements or facts, the facts that the matter of your orders were clear. The Gage is supposed to be here for spring break 2020. I made every attempt to have my son here, even offering to drive or fly to Seattle to see my son. It was ignored by her a la carte attorney. It was ignored by her. And in return, she fires back, says that I'm threatening or harassing her, which all I'm trying to do is abide by the orders that this court set forth. If these court orders are in my son's best interest, it's clear with just the exhibits that I have presented that is not in his best interest, Your Honor. Turn your exhibit, look at Exhibit 4, his hygiene. His hygiene, he has I can't hear you. Are you there?
I saw the photos. The sneaker size 7.
Yes. Yeah, he wears a size 8.5. His clothes were too small. She's sitting to Vegas in sweaters and hoodies and clothes that don't even fit him, and shoes a size and a half too small. Willfully. On purpose. You know, I lived with the plaintiff for 20 years. I know exactly how she is. She wears Coach. She wears Louis Vuitton. She wears all high-end stuff. And to send my son with rags, it's a clear defiance move, Your Honor. Very clear. And his hair, his hygiene is ridiculous. So again, going and for Faith Lutheran, if you look at the exhibit for Faith Lutheran, they know who my son is. They were willing to bypass all of the normal admission process to get my son into 8th grade. It's clearly documented in the emails. It was not until the Mrs. Norcutt called Faith Lutheran, made a stink, and God knows what she said, then all of a sudden Faith Lutheran turned their back on my son. This is all a mirage that has been presented to you, Judge Moss. I would not climb up this hill and fight this fight by myself if this is not what the best interest of my son. The best interest of my son clearly outlined by the state rules and factors of the relocation process. He lives in an apartment. She sleeps on the sofa. He shares a bed. I mean, all the things involved has been a clear mirage based on fraudulent allegations of domestic violence that never took place, Your Honor, or have been exaggerated to the fact that holds no weight at all. And we've already argued that. So again, estoppel, I'm trying to save the taxpayers' money, trying to save your time. We cannot allow my son to return to Seattle, Washington, Your Honor. He is at extreme risk right now, moving into a pivotal time in his year in 8th grade, failing the 6th grade and the 7th grade with all F's. And the only reason why he was able to pass the 7th grade is due to the grace that his teachers and administration had on him, because of my involvement from afar, begging for grace for my son, and trying to, and then Mrs. Norcutt also claims that he's in tutoring. She claims he's doing better than ever. Well, the fact that you see the exhibits that I filed by his school counselor and his dean that Gage is not participating in any tutoring. He's not taking place in anything at all whatsoever. In fact, after COVID, when COVID resumed, Your Honor, Gage was still absent from school for over a month. Over a month when when classes resumed. He had 40 missing assignments. He logged in but didn't do the work. He was playing video games and listening to the teacher, not even participating in school, with no direction and no supervision from his mother. You know, Your Honor, what are you doing in like, the best interest? You know, if my oldest son wants to change his last name, that's directed by the culture in the home. If Mrs. Norcutt, Mrs. Counsel, fostered and had a home of loving and care and patience and understanding, she would have that culture in her home. Obviously, it's a toxic environment for my youngest son to be involved because of the culture that's created in the home.
So, yeah, what were his grades, kindergarten through 5th grade in Vegas?
They were A's, C's, and D's. But he was an adolescent. He was a young child. You know, you can't say, well, his education in 6th and 7th grade should match 3rd grade and 4th grade, because that's all just behavior. That's just all learning to you tie your left shoe and your right foot. Those are beginning developments of education. They serve no record, or they hold no weight of an 8th grade child that has the potential to forever forge his future. You're talking about a high school that if you go to this high school, Your Honor, 99.9% of all children, their future is forged for them, and they have every opportunity given to them as long as they do their part. Now, that doesn't mean he's going to go to the NFL and play football, but he would have the opportunity to go to a D1 school to figure out what he actually wants to do with his life if football's not the case. It's not about football. It's not about athletics. It's about a pathway that's been provided for him that is in his best interest. And then I also filed today, Your Honor, an exhibit number 8. You know, and their argument is going to come back and go, well, what successes has he had in school? If you look at his entire 6th and 7th grade, he's had no achievements. He hasn't even been recognized for good attendance, anything. This short period of time here at the YMCA, he wears these bracelets on his arms, so he's so proud of his respect. He's proud of his participation. He's proud of all these awards that he's been identified by the Y in a short period of time. He's received more achievements in 2 weeks than he has in 2 years. And he's proud to wear those. Your Honor, the mother has totally defied all the court's orders. She's defied the best interest of my son, just because if I say so, it's destroying everything that he has. You know, and if you continue on down this path, it leads for all the adolescent misbehaviors. If Gage is allowed to continue school in Seattle, he will go down a path.
To respond that Mom said she hasn't talked to him all summer long.
Gage called, someone hacked into my email address that's tied to my Skype account. My Skype account is locked by Skype. Gage has called his mom from my phone any given point in time he wants to, and I have record of that, and it's called her when he wants to. Gage, Your Honor, has felt a relief of a non-toxic environment that he is in right now because he is out from underneath the umbrella of his mother. His mother has done nothing at all to foster the relationship or have a culture in the home that warrants the relocation approval. So yes, he has talked to her.
So how often since the day he arrived in Las Vegas this summer has he talked to his mom?
He has, I don't know the exact times because it's a non-issue. Every other night, by night, but the phone is right in his room when he plays his PlayStation with his buddy. And I said, don't forget to call your mother. The alarm is set. Now, whether he chooses to or not, I can't control that. But I have verbally told him, make sure you call your mom. Make sure you reach her. Make sure you at least text her or make an attempt. The response that I get is that, oh, I forgot. So in respect to his lack of caring to call, I have grounded him from playing the PlayStation until he does do so.
So he has to call his mom so he can play his PlayStation?
No, not in my presence. I gave him the phone, and I said, hey, when that time comes, the alarm's going to go off on my phone. It will remind you to call her because he's only allowed to play a couple hours in the evening, right? Because he calls it me time. Make sure you call your mom. So I don't have to want to come up here and remind you. I've got things that I have to do on my own, right? I got household duties and other things that I have to attend to. I'm giving it up to you to make sure that you call her, whether he chooses to or not. And to be honest with you, Your Honor, he hasn't even wanted to call his mother because he has felt like he has been forced to not even give, he has been forced he is being taught to hate me. And
Yes.
like I said, Your Honor, like I said,
the mom's gonna say the whole June, July, August he's been there, he hadn't made a single phone call to his mom?
of course. No, he has. Absolutely he has. And I have all the phone records to prove them. I'll download them and upload them tonight for you. Absolutely he has.
That was my question. How many phone calls were made over the summertime?
I don't have the direct answer, Your Honor. Let me, not to take away time or anything like that, but I can look at my phone. I can look at the history. It will show you everything because I don't delete it. I keep it there just for instances like this, Your Honor.
Right.
Here we go. We got the 20th. We got the 18th. We got the 14th, the 10th. Multiple attempts and conversations called. So for her to say that he hasn't, he has multiple times. The phone, it's right there in my phone.
Don't they text each other as well? Does he text his mom?
I don't know if he's texted her from this phone or not, but he's more than welcome to. Absolutely, at any given point in time. He's more than welcome to, and he will tell you that himself. I said, you can take the phone, you can use it, you can do whatever it is that you want to do. Absolutely, right? And I don't even know the phone that she sent with him. The charger was lost, and we have found it. But again, I don't know if she's coerced my oldest son to even change his last name. I don't know what she's even implemented with Gage right now. He's felt presumably, all the court orders are put in place for the child's best interest. Presumably, right? Now,
I still don't know your plan for Faith Lutheran or public school.
Okay, so Gage has an opportunity. Gage has already been accepted into Faith Lutheran at 9th grade. However, if he doesn't make it into Gorman, he is approved. He will be in Faith Lutheran at 9th grade. Worst case scenario, if his grades are not there, he would go to Faith Lutheran and transfer to Gorman, putting behind a semester. He is also slotted to go into, and I can show you the email today. I talked to the administration over at Game Changers. He's slotted to go to Game Changers as well. Game Changers is a new private school to where it's all based on around athletics. If you look at my son's report cards, right, the only class he excels in is physical ed. Your Honor, that's got to say something. It has to say something to you. You have allowed this to go on for 2 years. 2 years this court has allowed this. She's had her opportunity. She has had the opportunity to focus on his education. She has yet to do so. Okay, we'll take it with the benefit of the doubt. Maybe the first 6 months of 6th grade, the transition, the stress of everything involved. But by then, he should be getting A's and B's.
What's
He
up
can't
with
even get to class.
behavior incidents at school? And I'll give you an extra minute here. I want you to tell me What did you learn about Seattle behavior incidents at school?
His behavior, and let me pull up. His behavior incidents.
Yeah.
I'm sorry.
Yeah, just the
His
specifics of it. Was he like fighting with another kid?
Fighting,
or like
yes.
talking to the teacher?
He's fighting kids. He's slapping kids. He's disrespecting teachers. He is defying complete authority. And it's not just one time, it's multiple times, Your Honor. And like I said, this is the 6th and 7th grade. Not only did it continue, and then, okay, so his behavior incidents, they were notated by the school. Mrs. Norcutt, Mrs. Counsel, never notified me, hey, by the way, Gage had a problem at school today. How would you like to handle it? How would you like to discuss it? I was not even given the right, nor was I even given the right. It was
How did
given
you
from
find
me.
out then? After the
I found out after the fact, reaching out to the counselor, asking, has Gage had any issues at school? How is his behavior? And then I get the wool pulled off from my eyes to what the true story is that he's actually failing. He's not eating his lunch. He's not getting the lunch provided to him by his mother. He's also not only being late to class, he's not making any attempt to walk to class on time. He's fighting with not only his peers, but he's fighting with the teachers. This is in 6th grade, right? And I can give you the benefit of the doubt of the transition period, right? Like you stated, the cooling off period. Well, it continued all the way through the 7th grade, Your Honor. And the school didn't even know how to contact me because I wasn't even put on the emergency contact card. I gave you that in the exhibits that on his school records. I'm not even listed as his parent. You got a cousin and an aunt listed as a parent. So you tell me, Your Honor, is his best interest in mind? Absolutely not. And not only was it done in the 6th grade, it was done in the 7th grade, and also going into the 8th grade, Your Honor, I'm still not even listed on as emergency contact. So Gage arrived in Las Vegas with ringworm all over his body. All over his body.
Okay,
so
you're 2 minutes over. Save that for rebuttal if you missed anything. I'm going to go with Mr. Page, and you've got the floor now, Mr. Page, for 30 minutes, up to 30 minutes. Go ahead.
Back in March, there was supposed to be spring break. We informed Mr. Counsel that Gage would not be getting on a plane because of COVID. He then threatened my client that he's going to file a motion to have her held in contempt because she was not putting Gage on a plane during the inception of the COVID pandemic. He has told you today that he offered to fly up to Seattle. He offered to drive up to Seattle. I challenge Mr. Counsel to provide a single piece of paper, a single email, a single letter, a single text, wherein he agreed or he offered to drive up or fly up to Seattle. He cannot provide it because it didn't occur. He is, to put it bluntly, lying through his teeth. I do not understand for the life of me why he is permitted to go on by just making up stuff as it goes along. All he did here for the last 30 minutes is engage in a rant against Ms. Norcutt. This is supposed to be a court of law. Yes, I'm complaining right now. He is supposed to provide facts, he is supposed to provide the law, and he is supposed to provide some analysis. It is not our job, it is not your job to do that for him. If he wants to have a change in custody, he is obligated to provide some sort of cogent application of Ellis versus Carucci. He hasn't done it. He hasn't indicated what the material change in circumstances is. I am sorry. A child having long hair is not abuse and neglect. Some parents choose to have long hair for their kids. Some parents choose to have short hair for their kids. That is not a complaint. He claims that Gage's shoes didn't fit him. Provide some proof of that. Attaching some pictures to an exhibit is not proof. If he believes that Gage actually had ringworm while in mom's custody, then go ahead and make a report to CPS. I see nothing in that regard that would rise to the level of a material change in circumstances. He claims that Gage is taught to hate him. Again, saying it is because I say it is doesn't make it so. Him saying that the culture at mom's house is toxic. Him saying it is because I say it is doesn't make it so. He claims that mom's abusing Gage emotionally. Saying it is because I say it is doesn't make it so. He is sort of engaging in closing argument here without any reference to any of the underlying record for anything that's occurred so far. He says that mom neglects his basic needs. Again, where is the report to CPS that that mom's neglecting his basic needs? He says that he's not even listed as a parent on the school records, yet at the same time he's saying, oh, Gage couldn't have done as well in school as he did when he's in Seattle if it wasn't for his involvement. He can't have it both ways. He can't say that Gage is only scraping by in Seattle because he's involved, and at the same time say that he's not even listed as a parent, so he can't be involved. Again, he just continually lies at every juncture that he has. He says that athletics provide structure and kids do better. You can't just say it and conclude that it's true. You have to provide some analysis, some evidence, something. This is a court of law that any of these things that he's spouting off about actually makes a material change in circumstances. He says that he's paid support and then claims that, oh, he couldn't pay support because all the things that mom has done to him. Well, nothing mom has done to him has prevented him from paying support. He says he can't pay support, yet he can enroll this child into Faith Lutheran at whatever $1,000 a month they can charge, or the $1,500 a month that Bishop Gorman charges, and says he can be in there tomorrow. Which one is it? Either you pay support or you don't, and if you don't, then you can't afford to put your kid in private school. You can't have it both ways. Again, you just lie after lie after lie. There is no evidence that this child is accepted at Faith Lutheran. There is no evidence that this child is accepted at Bishop Gorman. There is no evidence that this child is a D1 athlete. Whatever delusional thoughts Dad has are his delusional thoughts. They don't rise to the level of evidence. There is no all Fs. Gage has been getting through. Gage has never been a great student. We all acknowledge that. But he is doing better now than he was ever doing in Las Vegas. He's kind of getting to be, I'll have Mom probably chime in here with this, he's probably a D, C minus student. Goldie, what's his grade point average right now? Is she on mute?
Yes.
Sorry, I muted myself.
What's Gage's grades right now?
I sent those to you. I didn't know if I needed them. I'm sorry.
But you sent those to me at the last minute. I can't do things at the last minute.
I know. Well, I didn't know we were going to need them. It's just... Anyway, he passed all of his classes this year with nothing C minuses or above. Like a 2.0 is what it was, I think. I could look at it. But he passed every single one.
For Gage, being a 2.0 student, given his past academic history, given his past behavioral issues, is a tremendous improvement for him. He does have structure in Seattle because he has his brother there, he has his mom there. That is what he prefers to be. As to the claim that, Gage is available for Skype every day, Mom seldom, if ever, gets contact with Gage. His excuse is, somebody hacked into his email. That should expire of its own internal contradictions. It's just another excuse by Dad as to why he's not going to facilitate a relationship between mom and child. The fact of the matter is, the reality is that under Ellis versus Carucci, which Dad has failed to provide an analysis for, there is not a material change in circumstances affecting the best interest of the child, and Dad absolutely positively cannot show by any stretch of the imagination, even on an emergency basis, that there be a material enhancement of the child's best interest by changing custody. One of the things that you set out here at the outset of the hearing, that Mr. Counsel would have to provide some sort of analysis under Arcella as to why a school here in Las Vegas would be superior to a school in Seattle. Not only did he not provide any analysis in that regard, he failed to even cite the case in his motion. It's sort of, we're not using our time efficiently if we're spending all of this time to set up a record, and he doesn't even cite to the applicable case, let alone provide any analysis for that case. His motion should be denied on those grounds alone. But in any event, he hasn't shown adequate cause for there to be any additional hearing, any additional discussion regarding what school this child should be attending, this child should be residing. I understand Your Honor wants to allow him to make a record, but allowing him to just drag these proceedings out forever and ever is really also damaging to Mom because she has to invest her time. I have to invest my time. So we're asking that the motion be denied, that this court entertain Mom's counter motion because Dad hasn't paid any child support of any kind since February of 2020. He hasn't paid child support before that time. He's never contributed to the 529 account for Gavin. He's never done anything that he's supposed to do. He comes before this court with unclean hands, asking that this child go to a private school, and he can't even find the time to pay Mom the child support for which he's been ordered to pay. These are all incarceration offenses, and yet he's allowed to go on and thumb his nose at the court and not do the things that he is supposed to do. And there's really no good reason for it. This claim that he can pay for private school tuition, but yet at the same time can't pay child support to Mom.
I'm sorry.
It looks like here from an email that was copied to me that Gage is supposed to be with Ms. Cooley on Wednesday, the 26th of August, and Mr. Counsel is required to bring him there, and she is going to interview him in private. And again, Mr. Counsel is not permitted to discuss anything with Gage, and this will give the court some additional light as to what's going on. But in any event, I think even without Ms. Cooley interviewing Gage, there's not adequate cause for this court to do anything but for Gage to get on a plane on September 2, and that he return to Seattle, and that he resume school on September 9th. And I don't think with that I have anything further, Your Honor.
Okay, that was, Don, what time did you start? You started at 3:36. 11 minutes. Okay, and we'll save if there's any other sort of rebuttal. All right, I'll give you no more than 10 minutes, Mr. Counsel.
Okay, one moment, please. If you look at Exhibit 3, Spring Break, DEF 006, you will find an email, Your Honor. In the chain of emails that Mr. Page seems to have forgotten is, if you're looking at DEF 006, email sent 4/7/2020 at 3:56 p.m. after numerous amounts of my attempt to get a hold of even locate where my son is located at during this time. I clearly
006 is a Care Now receipt.
So it is notated, Your Honor. Let me read the email. So it is notated that not only is your client willfully choosing to ignore the court's orders, you are also responsible for the damage in complete disregard of the orders in place. I'm looking into airfares to travel to Seattle and would like to pick up my child and travel back to Las Vegas with him or spend it in Seattle during